Welcome to this June edition of WebeXions, and we're delighted to have Tollers with us today. As you can see on the title there, buying or selling a business, growth by acquisition or realizing an asset. We're delighted to have Brian Alder and his team at Tollers here to talk to us today. So without further ado, I'm going to hand over to Brian, and off you go, Brian. Thanks very much.
Great. Many thanks, Ian, and yeah, good afternoon. So growth by acquisition or realizing an asset. Clearly the options available to most businesses. Growth by acquisition is clearly the quickest, not the easiest, and not the least risk-free way of growing a business, but certainly a good option to look at, or simply exercises an exit in terms of you have an asset and you've now decided that you would like to realize that as a sale item. So we're going to take you through that process. So the presenters today, myself, and then we've got Danielle. Danielle.
Hello.
All right. This is a test just to make sure everybody is here and everybody can see and hear everybody. And Amy.
Hi. And
just a little bit of background for all of us. So I've been doing this probably for far too long. But it's great work. I still enjoy it, get a buzz out of it. And I basically sweep up everything that has got nothing to do with property because I know nothing about that, and certainly nothing to do with employment because I know even less about that. People that do know about that are Danielle.
Hello. I work with Brian and with Amy in the buying and selling of businesses, but I also work on property-specific matters, transactions involving leases, acting for both landlords and tenants and investor clients in buying and selling property.
Super, thank you. And Amy.
Thank you, Brian. So hello, everyone. I am an employment partner here at Tollers. So I work closely with Brian and Danielle when it comes to the buying and selling businesses and look at the employment aspects. But I also do all sorts of other general employment, HR-related work. So acting for lots of employers, dealing with their day-to-day employee problems as well.
Super, great stuff. So a little bit of housekeeping. If you know how to use Zoom, you're on this webinar. If you don't know how to use Zoom, I'm assuming you're not on the webinar, so I'm not going to say anything else about Zoom. Ask a question. Would you please keep those questions, those burning questions, till the end of the session? We will have an open sessions for Q&A. We would just like to get through the presentation rather than keep breaking it up for questions. So if you'd be good enough to stay on and ask your questions, we'll make sure there is plenty of time for Q&A. And then any feedback that you'd like to give in terms of the presentation itself, the relevance of the topic, or anything else that you want to comment on, that would be greatly appreciated. So what are we going to chat about today? Well, preparing for sales or purchases, the things that you can do before you take the decision whether you're going to buy or sell a business. We're going to focus on the three principal legal aspects of buying and selling a business, and those are the three disciplines listed: company commercial work, that's me, property with Danielle, and then employment with Amy. Give you an overview of the stages of a transaction. So all transactions, big or small, follow the same stages, and it's helpful for you to see that in a helicopter view and to learn a bit of vocab. And then we'll go into the Q&A. So first of all, get your transaction team sorted out. The three disciplines I've mentioned, they're key. Accounting is the other side, really, the equal other side, if you like, to this tale, because valuation of the business, whether you're buying or selling, the tax implications and accounting advice are absolutely key to understanding and then shaping the deal that you're going to enter into. We don't provide that advice. We work with accountants to do that. There are transaction accountants, as there are transaction lawyers, and they are a different sort of skill set. And there's no shame in your accountant saying it's not my bag, but I'll work with a transaction accountant and the two work together. And that's not an unusual combination when it comes to an exit, to a purchase or a sale. You may then, depending on the sort of business that you have, need other expert advice. If you're heavily into intellectual property, then you might need some input from patent and trademark attorneys, but there are other sectors as well. Financial services, for example, there may be input that you would require in terms of compliance and other issues. So hence the question mark, others, depending on the sector that you're in. So I'm just going to give you a very quick overview in terms of the preparation that is as important as any other process, and something that most businesses don't indulge in. They go off to try and find a target, or they decide they're simply going to try and find a purchaser, and the amount of preparation is usually minimal, and that doesn't help. So the first key question that needs to be decided, normally this is on the advice of the accountants, do we sell the assets of the business, or do we sell the shares in the company, assuming it's a company? The main distinction being, if it's an asset or business sale, then you're only acquiring the assets and liabilities that you decide you want to acquire as a buyer, or indeed sell as a seller. The only non-voluntary element to that is normally the employees, and Amy will introduce the delights of Tupi to you if you haven't already experienced it. On the acquisition of or sale of shares, then you acquire the whole trading history of the company from year dot, so from its incorporation. So clearly that is a different risk venture and a different mindset and additional preparation and due diligence that you need to carry out to make sure you know what's within that business. The preparation, certainly in terms of a sale, is collecting everything and anything to do with your business. The due diligence process, which I'll come on to shortly, is about asking you a load of questions about your business and then asking you for information and every piece of documentation you've got in terms of how you evidence the internal workings of your business and the external workings of your business. So that would be everything from employment contracts to standard terms and conditions of sale, to agency, to distributor agreements, to software licenses, etc., etc. So it's a massive paper chase. I'm not going to say anything about property because that's Danielle's specialist topic. I'm not going to say anything more about employees because Amy's going to tell you all about that. The due diligence exercise, which is usually the preamble, or usually takes place after you've got a good idea that you have a deal. Normally, that would be evidenced by way of heads of terms, and I will mention that later in this presentation. But it does consist of a huge paper chase. There may be tax clearances needed, not for most transactions, but again, your accountant will tell you whether that's something you need to sort out before you pile in and start doing the transaction. There may be a whole load of guarantees that you've entered into as part of your business, and you'd need to make sure that you get rid of those as part of the deal. There may be a variety of licenses that are particular to your business that you need to ensure or understand what will happen to those on the sale. So principally things like alcohol licenses, or even licenses, with respect to the FCA and other regulators. Deferred payments are a key issue. Any payment that you don't get paid at completion represents a risk payment, and the automatic response to deferred payments is, well, what security am I getting? Earnouts, basically saying, look, if you stay on, or sometimes if you don't stay on, part of the price will be linked to the profitability of the business. Although I did a deal not that long ago, and it was software development was an earnout. The profitability of the business was an earnout, and doing some debt collection was also part of an earnout. IP, another property aspect to the business, is that key to the business. And in this day and age, even if it isn't, things like data protection are always an issue that you need to fully cover off. There may be competition law issues that you need to be aware of, unusual, certainly in the marketplace where we essentially act for sellers. Our clients do not have dominant positions in the marketplace or indulge in price fixing and other matters that could come to the attention of competition authorities. Having said that, national security wasn't much of an issue until recently, but now there's legislation that can cover a whole variety of businesses, and that's one that is now very firmly on the checklist. Anyway, that's your sales prep, that's your overview. And now we drill into that, and over to Danielle to tell you everything you ever wanted to know about property.
Right, well, property is obviously my remit, so perhaps I'm biased, but it's a really important part of any business sale or purchase because of the asset value of real property. It's often a significant proportion of the business's tangible assets. Property can either be held as freehold or leasehold. Freehold is when you have full ownership of that property. So there are fewer restrictions about what you can do, but you're solely responsible for that land. The owner is solely responsible. With leasehold land, the ownership is limited to only a fixed set term, but that could be a long term if it's long leasehold of over 99 years. But under the terms of a lease, it's the land itself is owned by another party. And so the tenant has to adhere to certain terms and they need to pay costs such as rent to the landlord. So first we'd assess whether we're buying or selling, what property is involved and whether that property is leasehold or freehold. We then look at the title documents. Now, title documents basically set out the ownership and management of the property. And in leasehold land, that would include leases and licenses, such as licenses to do alterations or a license to assign, which is selling the lease to a third party. So there's various documents. There are also the title deeds, which are held at the land registry, and they just give a clear picture of the property. And that's what's really important, is whether if you're buying, you want to know everything about the property that's involved. And if you're selling, you are duty bound to provide that information to the buyer. So the title documents basically define the rights and responsibilities involved in the land and who legally owns the land. In the title documents, there will be charges or restrictions. So charges and restrictions are basically legal limitations or obligations on the landowner. Common example of a charge would be a mortgage, because property is often used as security for financing. So if you're buying a business and there's property with a mortgage on it, you don't want to buy that property, that business with property with a mortgage on it. So that mortgage needs to be paid off at completion or before completion. So those things are very, very important. An example of a restriction would be an easement, a right of way. So another party, the neighbor, might have use, or if it's an industrial estate, and they might have a right of way across your land in the event of a fire, or there might be some right over your land, and you need to know that that's there because it could affect the value of the land, which could ultimately affect the value of the transaction. Another thing that we would look at is the plans of the property, and that might seem really straightforward, but you want to make sure that what you think the company has in terms of property is exactly what it is. So, for example, if it's freehold land, it might straddle two titles. So there might be two separate plans that, when they fitted together, create the land that the company owns. And the importance of that is that there'll be two separate title registers, which may have different charges, different restrictions on them. So you just want to make sure that you're getting everything so that nothing trips you up later down the line. Another important step along the way when you're buying a business is to obtain desktop searches of the land. This is a standard part of the due diligence process because they just sort of provide you with history and details about the property. And you can also see if there are any environmental issues. A local search, a local authority search would let you know if there are any planning restrictions, planning consents, and they could affect how you propose to use the property, or in fact how the property is actually used, because if the current authorized planning use isn't how the property is used, then that is an issue that needs to be smoothed out before you complete, if you're acting as the buyer. And if you're acting as the seller, well, no, it's only if you're acting as the buyer the search is, so ignore that bit. Just trying to, it's difficult to always think about whether it's a purchase or a sale, because both are obviously the opposite of one another, and so different factors are involved. Another part of the due diligence process, if property is involved in a business sale or purchase, are the commercial property standard inquiries, commonly known as CPSEs. They're just basically a standardized form of questions, and they're generally not particularly useful because the seller completes them for the buyer and generally caveats every answer with "so far as the seller is aware," or as far as the seller's aware during its ownership of the property. And so there's not often much useful information, but they're still worth going through because the key information that is in there, it is quite handy. For example, if there's a landlord and they've opted to tax the property, then you know that VAT is chargeable on the rents, and you get the VAT number. That's one of the questions. Another one is who's responsible for the boundary features. So you know exactly who is responsible, so that doesn't cause conflict later down the line with your neighbours. It enhances the transparency of disclosing the information. Another question in the replies is about insurance, making sure the property is insured, whether there are any ongoing claims, whether there's a health and safety file, a fire risk assessment, asbestos management survey, all these kind of important documents that you would want to get when you're buying property to ensure that it's in line with the regulations, and if that information isn't available, why it's not available. So the CPSEs at first glance don't appear particularly useful, but they can provide quite important information. That sort of covers certificates. You want to try and obtain electrical certificates, fire safety certificates, asbestos management surveys to confirm that everything's in order. It's just general due diligence. You want to have as clear a picture as you can about the property, because it can affect the value of the business. And if you're selling, we get all this information from our clients before the data site is open, so we can put it all in there and we can say to the buyer, here you go, this is all the information, and they've got everything they need. It's the most succinct and efficient way of dealing with things, is to be as upfront as possible about the property. The last point on my slide is surveys. They're not something that we carry out. That's a third party who would carry that out. And it's just the same as if you're buying a house. You should always do a survey. Yes, it's another upfront cost, which you may not want to invest in, but it protects your investment ultimately, because it prevents, or should prevent, future legal or financial complications. So we do always recommend that our clients do complete surveys on the property that is involved, that is owned by the business that they are purchasing. Also, if there's a mortgage lender involved in the transaction, then they generally also insist upon surveys to once again confirm the boundaries, make sure that the property and its features are accurately documented, make sure the value is correct. It reduces the risk, so it reduces risk for the mortgage lender, and that ultimately means it reduces your risk as well. So basically, at the end of the day, when we're acting for the seller, we want to prove clear and marketable title. We want to prove that our client has clear and marketable title to the property. If we are acting for the buyer, we want clear and marketable title at the end of the transaction. So we basically act in the best interests of the client, be it buyer or seller, to ensure that their rights are protected, so that they can ultimately achieve the best possible outcome for them, and that the process is as efficient and effective as possible. And that's about it about
Super.
property on that slide.
That's great. Thank you. Just a couple of questions, Danielle, if you don't mind. Frequently asked about, well, can we leave the property out? What would be the options as far as you're concerned in a transaction?
Well, you referred to heads of terms at the beginning of this talk, and it really does partly depend what's in the heads of terms. So if we're acting for, if the seller, wants to retain the property, then, well, let's start from the beginning. A business sale or purchase could be an asset sale or purchase, or a share sale or purchase. Now, property is obviously an asset. So if it's a share purchase or sale and the buyer doesn't want the property, then we would need to carve out the property. So we would assign it, which is effectively selling it, to another party, probably a group company of the seller. So we would effectively take it out of the transaction. Another option is, another option if it was an asset sale or purchase, is just to not include it. Sometimes the seller likes to retain the property because it's a source of income, and it's worth retaining for that revenue generation. And so they often lease the property back to their buyer. So yeah, we've had experiences in the past where our clients who are sellers have simply assigned it to a group company and then leased to the buyer.
Great. And while I'm getting free legal advice, just another question.
Yeah.
Not so long ago, we had an issue about landlord's consent. So in terms of me managing a transaction, I'm always trying to identify areas that we can control and what we can't control. So landlord's consent, is it a given?
No. Landlord's consent is never a given. It's a third party involving themselves in that needs to be involved in the transaction, which can hold things up. It can make things more expensive. It's a factor to consider only, though, in an asset deal. So in a share purchase, sale and purchase, you're buying all the shares in the company, and so the tenant in a lease remains the same. So the landlord doesn't need to be involved. But if it's an asset sale or purchase, then the tenant will be changing. And in order for the tenant to change, we need landlord's consent. And under the terms of most leases, if not all, the tenant is responsible for the costs of the landlord's solicitor in effecting the assignment.
Super. Great. So now for something completely different. Let's talk about employees, Amy.
And much more exciting.
Hi.
Oh, please.
You don't sound like passionate about property.
Employees, massive part of your business. They are your biggest asset, but they're also your biggest headache. So when it comes to buying and selling a business, you're in the same predicament. They're also the major asset, and they're also the major problem, and where you're likely to find problems and issues and things you have to deal with. As we mentioned before, there are different ways of dealing with employees, whether it's an asset purchase or a share purchase. But in either option, the first thing that you have to do when it comes to your employees is go through a due diligence exercise. I know Brian's talked about that, but that's basically where, if you're selling, you give the purchasers all the information that they require about the business to enable them to be aware of what they're buying, and ultimately let them decide whether they want to buy it. If you're the buyer, you then review all that information and decide whether there is anything nasty lurking in there that either you don't want, or you want the buyers to sort out prior to completion, the sellers to sort out prior to completion, or whether you want to start, I'm going to say, fiddling with the price, or adding promises and documentation and effectively repayment clauses in the actual transaction documentation. So the due diligence process is really important. And when it comes to employee due diligence processes, it can take quite a lot of time, because the types of questions they ask are, they want the minutiae detail. Okay, so They always ask whether you've got employment contracts and staff handbooks. They always ask to see everybody's, or they always ask to see precedents. They want to know everybody's start date, end date, salary, holiday entitlement, whether there have been any grievances or disciplinaries, flexible working requests, everything like that you will be asked for. Now, lots of times when we're acting for sellers, I get thrown back the question, why do you want all this information? I don't want this information, okay? The buyers want this information. And depending on who the buyer's lawyers are, is you might prepare all this information and provide them. Then they'll go through it with a fine tooth comb and pick out specific questions or specific issues that they think they might have and ask those questions again, or ask for more information. Now, I'm going to say I always feel a little bit sorry for sellers, because when I go back and ask for all this information, they feel like they're getting got at, shall we say. You know, they're asking for so much detail, and you've got the purchaser saying you've not got employment contracts. It's not, this scenario isn't when you've also almost got to get a thick skin and go, okay, this is the business, this is what I'm selling. I'm not going to get upset that someone is coming in and questioning every aspect of my relationship with my employees. So you've got to be prepared, okay? They even ask things like, have you got right to work checks? Have you checked the right to work on all your employees? Have you got working time and their working hours logged somewhere? Can you prove you've been paying the minimum wage? What sickness absence of employees have got? So if you are thinking of selling at some point in the future, I cannot stress enough how important it is that your employee records are up to date. Because if you start putting all those things in place now, making sure you comply with the relevant laws and everybody's got contracts and things, then it will be a million times easier than trying to deal with it when it comes to the sale. Because when it comes to the sale, you haven't got time to add employment contracts, and you haven't got time to figure out, who's worked in breach of their working time hours. And what will happen in the transaction documentation is the purchasers will say, that's fine, we'll take your business as it is, but we may reduce the price because of the potential risk. Or in the event that there's any claims or investigations, then you as the seller may be on the hook for any losses or consequences of those errors. Likewise, when we're acting for purchase, we do the same thing. We will say to the seller solicitors, but you've not complied with X, Y, and Z with regards to your employees. We think the potential cost of the business is going to be, I don't know, X amount. And that is and that's what we factor into the negotiations then. So my bit of advice about the employees is they will drill down into the tiniest minutiae detail. It's not in any way a criticism of you or thinking that you've not done anything correctly. That's their job, but you have to have all that information to hand, because I have seen transactions held up for months and months and months because actually the employee information is not in a readily disclosable source. They can't, it's not there. So when someone asks a question, it takes 3 days to find the answer to it. So if you are ever thinking of selling, your employees, your biggest asset, but also your biggest nightmare, and they will continue to be so until the day you get rid of that business. So my advice there has got to be organized and have everything in place now, because it will actually save time and cost and a lot of stress further down the line. So that's the due diligence process. Whether you're buying or selling the shares in the business or buying or selling the assets in the business, that process will be exactly the same. What then differs is what happens to the employees. So if you're buying the shares in the business, I think as Danielle mentioned with the landlords, the employer remains the same. You're buying the company. So those employees in that business remain employed by that business, and the company always remains the employer. So that's a relatively straightforward process. You will have to tell the employees at some point that the company's got a new owner, but on a day-to-day basis, there's no process to go through, and nothing will change for those employees. And the law's relatively relaxed. You would be able to deal with those employees like any employer would, because the employer has remained the same. When things start getting complicated, it's when it's an asset purchase. So I'm sure you might have heard of this lovely expression, TUPE. Okay, TUPE stands for the Transfer of Undertakings Protection of Employment Regulations, and it's the protection of employment bit that actually is the important bit. And what that document and what these regulations effectively say is if a company is selling its assets, the employees travel along with the business to the new owner. Okay, it's a piece of European legislation, but I can't see the fundamental principles changing because of Brexit or anything like that. So if TUPE applies, the employees that are specifically assigned in that business will transfer to the new purchasers, and the process you have to follow will be to consult with them. Okay, you'll have to tell these employees. If there's over 10 employees, you may have to appoint employee representatives to consult with them on a collective basis. Now, that process is relatively straightforward, provided that the purchaser is not going to make any changes to those employees' terms and conditions. Generally, the regulations stop any changes to employees' terms and conditions. So they don't want anything to do with the employees changing just because there's a new employer. There are various circumstances when those changes can be made, but if you're going to do that, you need to consult with those employees and obtain their permission. So in lots of these instances, people, think, oh, it's the employees, it's fine. Then all of a sudden you get to nearly completion and the purchaser tells you that you want to change, change payment terms or change payment dates or change the location all these employees work. And that complicates things, and that ultimately holds up the transaction. So what you have to be mindful of in an asset purchase is there is a set process that you have to follow with regards to the employees. And the regulations say if you do not follow the correct process, provide the correct information in a timely manner and the correct way, then there is the potential for a tribunal to award up to 13 weeks' wages per employee. Okay, so even if you've got 10 employees, that's still a heck of a lot of money to be paying if you've not followed the correct process. So TUPE is something that is very important. So we go from share sales being, relatively straightforward when it comes to the employees. We've got asset sales where you sell the whole business for TUPE. That again is relatively simple. The most complicated scenario is if you sell part of a business. Because if you sell part of a business, what you have got to decide is, out of your employees, which ones are specifically employed in the part of the business that you are selling or buying. Okay, so the part of the business that you are keeping, the employees stay with their original employer. In the part of the business that you are selling, those employees move with the part that you're selling, which in some businesses is really straightforward. The areas of concern are usually, admin support, finance, people like that, where they work on the whole business rather than a specific element. So that sometimes can take some looking at. There's lots of legal arguments and legal positions to consider, and it also means you end up sometimes having an argument with either the purchaser or seller, so you know who you're going to inherit, and you think perhaps the seller has slipped in some employees that shouldn't be transferred, or the buyer thinks that there should be some employees that you're keeping. So that's something that you have to consider as well. So when it comes to the employees, there's the due diligence, and then there is what actually happens to the employees, and that is something you need to consider at the head stage. It's not something that you can just decide further down the line, because you will need to know that early on in the transaction, so both sides of the transaction know what's going to happen with regards to the employees. A couple of other things to mention are, if you are selling a business or if you are buying a business, it works in smaller owner managed businesses. Ultimately, it's the owners that have the connections, it's the owners that have the information, and often when you're selling a business, the purchasers want to keep the owners there at least for a period of time. I think Brian's mentioned earn-out periods and things, and that's quite standard, and it's quite normal for sellers to remain in the new business going forwards, and that often means negotiating and agreeing on new employment terms with the buyers. Likewise, if you're thinking of buying an organization or a business, you need to make a decision as to whether you actually want the sellers to remain in the business post completion, and if you do, on what terms. What are you prepared to pay them? How long do you want them in the business? So that's all things as well that will affect the employee side of the transaction. So your employees, like I say, your biggest asset, your biggest worry, your biggest risk, and they will be till the day that you no longer own that business. But the best bit of advice is get your house in order now. So it actually makes this process much more straightforward. Thank you, mate.
Great stuff, thank you. So to continue the theme of, but I don't want to sell these bits, there's any amount of times I've been told, love the business, but don't want any of the employees, or just want one or two of them. So what are the options?
What are the options? Well, it depends whether it's an asset purchase or a sale purchase. Like I say, if it's a sale purchase, then you would just deal with dismissing the employees like you would an ordinary dismissal, conduct capability redundancy, or perhaps settlement agreement them out. If under TUPE there's an asset purchase and TUPE applies, it's much harder to dismiss an employee, because if you dismiss an employee because of the transfer, or because the purchaser doesn't want them, etc., then that will automatically be in breach of the TUPE regulations. You can still dismiss employees because of their conduct, capability, redundancy, etc., but you can't just get rid of employees because the purchasers or the sellers don't want them anymore. There are, of course, ways around doing this. There are always ways around. If you are purchasing and you are adamant you don't want X, Y, and Z, you could say to the sellers, well, look, that's fine. We want your business and we're going to pay X amount for it, but you need to do A, B, and C before we're prepared to complete. Or often there is documentation that says perhaps we're going to make X people redundant post-transfer, but it will be at a cost of the seller. So it really is, there are various laws that prohibit things, and everybody knows there's usually a way around it, but it's sometimes dealt with in the actual transaction documentation themselves. So everybody knows what the position is going forwards.
Okay.
But what I would say is when someone comes to you and says, I don't want any employees, or, we get instructed a lot saying, I'm buying these assets and I don't want, no employees are coming. It's not as straightforward as just to go, okay, no employees are transferring. There's a legal test and the laws will apply. So you can sometimes not get those employees, but it's not just as simple as making that decision. There will be steps that have to be taken in a certain way to ensure that those employees don't transfer.
Okay, just one other while I've got you, Amy. Getting rid of or having a clean break with senior employees, normally the directors have to resign. And I'm always being told, oh, well, a letter of resignation is fine. You don't really need to do anything else. What's your advice?
Well, it depends, because when you're selling a business, you might not actually be an employee in the business. There are some directors that are not actually running the day-to-day business. But I would always recommend this settlement agreement. I'm sure all of you out there have come across a settlement agreement at some point in your lives. It's a legal document whereby the employee agrees to resign and not bring any claims in respect of the termination of their employment, not their directorship, not their shareholding, but their employment. Sometimes you can pop the promises in there in the transaction documents, but I would always recommend it is dealt with properly in a settlement agreement. And it's quite standard for directors. Family members that are often employed within the business as well often agree that their employment ends on the terms of a settlement agreement on completion.
Great.
Thank you.
Okay, so we've had my brief introduction and drilled into property and employment. And I'm just going to finish off by looking at the stages in a transaction so that you, I say, get a helicopter view as to what's involved. And as I said at the beginning, whether it's a big or small deal, this is the normal timetable and terminology that's used. So the beginning of the transaction is you're actually talking to somebody who is showing an interest, and or you've agreed a price, and you've had at least some preliminary discussions. You would want to enter into some form of confidentiality agreement, an NDA. Obviously, if you're the seller, it's highly likely all the info's coming from you. Normally, purchasers don't need to volunteer anything unless you're doing something like proof of funds, i.e. they can actually buy the business. I think every presentation I've seen on buying and selling businesses, they always say, beware somebody who's on a fishing expedition, that all they're doing is looking for cheap commercial information and pretend to be buyers. to be frank, I've never actually ever come across one, but that's always the warning that you give to say, beware of people that just want you to provide bits of information and bits of paper. So an NDA is the starting point. And we did, I will talk about data rooms in a second, but we did open a data room up to, or we're about to open a data room up to some prospective purchasers the other day. And we did our own little bit of due diligence on these prospective purchasers, and found one of them was purporting to be a director of a company that had actually been dissolved. So we thought, well, maybe that's not the greatest prospect in terms of somebody coming along and wanting to, or purporting to wanting to buy something. So beware. How do you keep confidential? How do you keep information confidential? You don't disclose it. Even when you've got the protection of an NDA, that's not an absolute protection. So these transactions, they follow various rules, including redacting information for data protection reasons, but also from sheer confidentiality agreements. Here's my sales figures, but you're not going to have my customer list until we're nearer the deal. So that's a sort of thread that runs throughout how you manage the process. Once you've got some protection by way of an NDA, then you would, I mean, I always recommend, even if the deal is relatively modest, that there are some heads of terms entered into. This is a sort of commercial shorthand to say, look, this is the deal. We've agreed the principles, haven't we? You know, fundamentals like price and payment, and is it an asset or share sale deal? And it still surprises me now when somebody says, oh yeah, we've got a buyer and it's all great, and the accountant's given us some advice, and and I say, so is it an asset or is it a share? I mean, there's only two options. It's not like there's a whole variety of them, and they say, oh, we haven't decided that yet. And you think, oh crikey, well, what are you coming to me for? Because anyway, so fundamental issues like that should be sorted out in the heads. I did mention data rooms, so this is really the due diligence exercise. As we've already said, this is a huge paper chase, and one way to electronically deal with that these days. Yes, I can remember the days of being surrounded by lever arch files and actually having a data room, which was a physical room that you allowed people into with a photocopier and supervised them. So anyway, I'm going back in, before horse-drawn carriages and all that sort of stuff. So I'll stop rambling. Now it's all electronic, and you set up a data room and pile into that as much information as is requested. If in doubt, shove it in the data room. And also, in terms of preparation, very few businesses do it, but we have done it for clients when they come to us and said, look, I want to sell, haven't got a buyer, but I want to do some prep work. So we say, well, look, here's a standard due diligence questionnaire, DDQ. 99 times out of 100, they're going to use this form. This is the information they want. We can populate a data room for you, anticipate all of that lot. And then when you've found some prospective buyers, all you do is open that up with the protection of an NDA. And you've taken a big chunk out of the process. And due diligence is by far the most demanding and the longest part of any transaction. Average transaction time, probably about 3 months from agreeing the price to completing. Yeah, I've done them quicker in a few days. And yes, I've done them in a lot longer period, over 12 months. But the due diligence is definitely the most time-consuming part. So anything you can do to short circuit that is a godsend, and the use of data rooms is great. You then move on from the due diligence, or while the due diligence is in process, to looking at the principal documents, and they're either a share purchase agreement. We keep saying it's either a share deal or a business asset deal. So share purchase agreement, SPA, business or asset purchase agreement, BPA or APA. And that is the key document that actually sets out the whole deal, all the promises that the seller has to give to the buyer, called warranties, and usually at least one indemnity on tax. There may be others. And the BPA, APA follows a similar format in that there are still promises given in terms of the assets that you're selling. So a bunch of warranties and potentially some indemnities. And so that's the principal document. When you've got that agreed, then you've got a transaction. The antidote for the seller in terms of all the promises that are in the SPA or BPA is the disclosure letter. So these are all the qualifications you want to make to those promises. So when the warranty says yeah, all of our employees have got employment contracts. In the disclosure letter, you say Joe hasn't, and then the buyer says, well, okay, get them signed up, or if that can't happen for whatever reason, whenever they then look at the matter post completion, say, oh, Joe hasn't got an employment contract, we didn't know anything about it, and you say, yeah, you did because it's in the disclosure letter. Now the thing is, they can legitimately say, we didn't know about it, even though you told us during due diligence, but you didn't put it in the disclosure letter. So that's a sort of key consideration. So if in doubt, you shove it in the disclosure letter if you're allowed to, because if it's not evidenced in the principal documents, the SPA, BPA disclosure letter, the buyer can legitimately say, I knew nought about it. So those are the principal documents. When you've got beyond those, you've got a deal on your hands. There are various other documents called, swept up by the term ancillaries, completion board minutes, resignation letters, and other documentation. And then you can move on to completion. Yep, and I can remember the days of being surrounded by bits of paper in a completion room, and all those have gone. Everything's done electronically. And the one story I will leave you with is completion is a formality. Nobody gets hung up on it, a lot of work to get there, but then you sign off and everybody's very happy. And in the days of a paper completion, I set up all my bits of paperwork in a great big meeting room, covered the whole table. My clients had flown in from Iceland for some unknown reason. They thought it was an exciting event. And so we were all poised, waiting to effect the purchase, introduce the buyers into a meeting room, say, look, there you go, catch your breath, you know, blah, blah, blah. And then when you're ready, come and Bob's your uncle, because there's nothing to negotiate at completion. It's done. Well, an hour later, they still hadn't appeared. And my clients were saying, we've got to go to Heathrow to get back to Iceland. And I'm thinking, good God, what could have gone on? Anyway, eventually they came through, signed up. But after the completion, I said, what on earth had gone wrong? And there's nothing gone wrong. But the mum was selling a third generation business, and it suddenly impacted on her what was going on. I mean, not that she wasn't aware, but suddenly the emotion of the event actually, I mean, this very rarely happens. Nobody gets terribly emotional about it. And she couldn't just sort of bring herself to go through with the event there and then. So they gave her some time, chatted to her, etc. Anyway, nothing ever dramatic happens on completion. Everybody expects fireworks and a clap of thunder, and it doesn't happen. Everybody's usually too tired to celebrate and just glad to get there.
However, Brian, there was the time you and I were working on a transaction many years ago, and we were due to complete on the Friday, and at 6 o'clock in the morning, our clients who were selling a lot of money sent Brian an email saying they were pulling out. And then he turned his emails off and got on a plane and flew somewhere very hot and remote, and we couldn't get in touch with him for 2 weeks. And we had no idea what was going on whatsoever. So they were interesting conversations we had with obviously the purchasers, because the deal was almost pretty done, and this guy just, you know, he disappeared off, didn't he? So fun things sometimes happen, but I think out of all the transactions we've done, there's probably only been that one that's never actually, once it's got to completion, not completed.
Yeah, and lots of folks say, you know, how many do not complete? And once you get to a certain stage of the process, usually heads, and certainly if you get beyond heads, it's very rare that people pull out, because by that stage, usually, you know, both sides have made a fair amount of investment. And also, it's traditional that both parties bear their own costs. So each party is running up usually a substantial cost. So I mean, not that they'll go ahead simply because they've incurred costs, but they've usually made a degree of commitment. And so that's a decent test in terms of them proceeding. But yes, there have been a handful, I think, where at the last minute, I remember one distinctly, the client said, I've never been happy about this buyer. They're not going to look after my people. I don't want to do it. And that was something like 2 or 3 days before completion. He then sold about a month or so later. But anyway. Okay, so that's the stages in a transaction. You've got some new vocab. You can see the helicopter view and how it proceeds. And I'm just now going to repeat what I've just told you. So preparing for sales and purchases, we've been through that. We've drilled into the commercial aspects, property and employment, and we've now just gone through the stages in the transaction. There's a wonderfully helpful flowchart that you can scan to your heart's content if you can use these QR codes. Or if you want to ask us to send it to you, just setting out most of that information in a diagram, and diagrams are great to try and understand transactions. So into the exciting bit of being inundated by questions.
Well, thank you very much, Brian. That's been fantastic. So, and really enjoyable. And thank you very much to Brian, Amy, and Danielle. We'll move into some questions. I'm going to, and I will then try and organize the screen, as it were. You've already done it for me, Brian. Well done. So basically, one question from me. I will, in my experience over quite a number of years in the finance world, it always seems to be signed at about midnight in my book. I don't know why it is, but I've often taken a train journey while all you guys in the legal and accountancy world are trying to do some stuff, and I just want to lend the money. So I just seem to be always at the end of the thing. But as we've said,
Hello.
Hello, who's that? Sorry.
Yeah, who's speaking?
It's Ian Taylor from Biz for Biz.
Yeah, I'm in the middle of a lecture at the moment. Sorry, I can't speak. Thanks. Cheers. Bye.
Well, I'm not sure exactly what happened there, but yeah. So as I was saying earlier, Biz for Biz have done a lot of work within the world of the baby boomers that are now probably coming to sell or exit their businesses. So it's quite a topical subject now, and on the terms of preparedness for sale. Interested to see what Danielle says, and particularly Amy, is that if you're the seller and you haven't yet got a buyer, there's a certain amount of sort of due diligence you can do yourself, because it tends to get delayed with searches and things like that. And Amy, you've mentioned employee issues, where in today's world, certain types of businesses will have employed a number of foreign nationals that are working in the UK and things of that nature. So I'd be interested from, say, Danielle or Amy, how can, when you're preparing your business for sale, what can you actually do to make sure you're giving good title, as it were, to a buyer that in some senses would indicate to the buyer that you're a well-prepared business and actually you're well worth the price. So there's no price chip at the end,
Yeah, I think from an employment perspective, you're preparing the business for sale, but on the other flip side of that, which you've not really touched on, is what they're asking you if you comply with the relevant employment laws. So it's also important for you, even if you're not going to sell your business, that you comply with the relevant employment laws. So it's things like changes to holiday pay, how you calculate holiday pay, minimum wage, all that kind of thing.
Yeah.
How you prepare your business for sale with regards to the employees is to make sure you comply with the employment laws. And that's going to help your business, whether you sell or not, whether you're going to sell in 5 years' time. It's also going to help prevent an employee bringing a claim or a grievance, etc., etc. So, being prepared and being nice and tidy and neat and complying with the employment laws is more than just about selling your business. That's when it's almost, you've got to explain to someone, but even for your own peace of mind running any business, you should be concerned if you're not complying with the relevant laws anywhere.
Yeah, no, thank you, Amy. And I know, Danielle, my experience is that searches, depending on the local authorities or wherever, on property seem to be a wide range of weeks.
Yeah, they can take a while, but generally it's 2 to 3 weeks, so it doesn't actually hold up a transaction.
Okay.
So long as we've got an idea of the title plan, we need to have a clear plan of what it is we want to be searched. So the first thing is to get that plan, and then we can order the search. And then once that's been ordered, we can continue with our due diligence. And to be honest, what we tend to do is ask our clients to just send us everything.
Yeah.
Anything they have on property. They might have old copies of the title. They might have documents that they received when they bought the property, as well as the documents since they whatever it is, we don't expect them to know. So we just ask them to send us everything. We then sift through it and organize it, and we fill in the gaps by going onto the land registry. We can establish what the title number is, and a lot of documents are saved to the land registry now, because most land is registered now. So it's really a puzzle process. It's a paper process. And it doesn't hurt the client, even if they don't end up selling, or if they don't sell to that party, because it just helps them organize themselves. But obviously, the more organized the client, the simpler the process, the more efficient we are, and therefore often the cheaper we are, because there's less to do.
I was going to say that because the transaction I've been involved recently, it's not it's a refinance, but there's always a deadline to try and achieve, and then all of a sudden they're having to enter into some insurance indemnity around the title and the access and stuff like that. That actually has cost another 2 or 3 grand when actually it didn't need to be if it had all been dealt with earlier on.
Yes, there are a variety of indemnity insurances which are available, and it's always interesting to see what you can find. But yeah, if sometimes I haven't had this experience, I'd like to say, but if the client doesn't have information, you get indemnity insurance, then maybe the client did have the information, it was a complete waste of money. But the buyer won't buy unless they've either got the document they require or satisfied that this isn't an issue, or there's insurance to cover whatever the issue may be.
Yeah. No, thanks, Danielle. So open up to questions to others. If you are on mute, please come off mute and just call out. I think, Keith, do you got your hand?
Ian, yeah, I've got a question for Brian. Brian, when you're acquiring a company and that company is cash rich, is there any restrictions at all now on using their finances to make the acquisition?
Yeah, I mean, it used to be criminal offence to use the
I
assets.
remember those days.
Yeah. So financial assistance for purchase of own shares, used to be a real headache for everybody, and the hoops you had to jump through. That's really now pretty much a procedural matter, as opposed to being something that you should be concerned about. I mean, there is a very small amount of compliance work to be done, essentially evidenced by way of the board minutes, unless you're a public limited company. But we're not in that market. So for most private companies, using the assets of the target is not prohibited as it used to be.
Right. Yeah. And just to make you smile, I've been involved in a number of sale and purchases, and right at the final stage on one, there was the factory being sold, which was straightforward, but the entrance to the factory also led to the entrance to the people who were selling their house. Their house wasn't part of the deal, and it came up at the last minute from a security side. The people selling would have to lock the gate, and the wife of the MD said, "If you think I'm going to lock the gate every night, forget it." So we all went into separate rooms, and in the end, we sold the house at the same time as the business. So Danielle, you'd have needed to be there for that. But
I would have enjoyed that one.
Yeah, it was fun for a few moments. But so it can be very enjoyable, and I always enjoyed the meetings at the end of the day. So electronic is good, but it takes away a lot of fun.
It does,
and a lot of champagne as well.
Yeah.
So do we have any more questions at all from the gallery? I'm just scanning at the moment. If you come off mute to ask a question. Okay, so there's no questions at the moment. So it just leaves me to thank Brian, Amy and Danielle and Tollers as well as a firm, which we enjoy your company immensely within Biz for Biz. So thank you once again, and we will see you soon after a little summer break on our next WebeXions once it's been sorted out, probably early September. Okay, thank you.